Thank you. I'm Ari Armstrong, representing myself. However, I also fought against the personhood measures of the last 2 election cycles with Diana Shea, who is also sitting in the room. I want to point out that there have been 2 people sitting in this room today who have been sued, dragged into court, for daring to engage in the political process. And in the United States of America, where we are protected by the First Amendment right of free speech, I think that is a travesty and a mockery of the First Amendment that Colorado citizens are being dragged into court for daring to practice their right of free speech. So I realize we're here to discuss your particular rule changes, but I think it's important to understand why these rule changes matter. And that is because the existing campaign laws, in fact, violate people's rights of free speech. We can tell this just by listening to the previous testimony. Here we have a state senator, Morse, whose legislative body has an army of their own attorneys, paid professionally by the taxpayers. And we have the Secretary of State's office, again with its army of attorneys, bickering about the meaning of the language within the constitutional provisions.
I'm not quite sure I have an army. I would like to say that. Maybe a battalion of
You have a battalion then. If a sitting state senator and the Secretary of State, with their battalions of attorneys, cannot determine the literal meaning of the Colorado Constitution pertaining to the campaign finance laws, how is the average citizen supposed to be able to determine the meaning and the application of those same finance laws? So one thing that John Moore said is that he thinks that the capping the fines to 180 days would incentivize people just to break the law, because he says $9,000 is just the cost of doing business to these large groups. Well, $9,000 may be just the cost of doing business to Senator Morse, but it is not just the cost of business to doing for me. For me, $9,000, I am sorry to say, is more money than I made in this entire year. It is not the cost of doing business. A $9,000 fine would throw me into an economic catastrophe. Yet for John Morris to sit there and say that getting fined $9,000 is just the price of transparency, that is an insult to the First Amendment and the Bill of Rights. He also said that, he also admitted forthrightly that the average citizen would have to hire an attorney in order to navigate these campaign finance rules. The average citizen is not going to do that. What's the result? Is the result going to be transparency, as Progress Now suggests? No, the result is not going to be transparency. The result is not going to be more information. The result is that citizen activists are going to shut up, go home, do what they're told, and not have a voice in the system. That's not transparency. That is a violation of their right of free speech. This is why the rules matter. And incidentally, Colorado Progressive Coalition suggests that they have this modest budget of merely $100,000 to speak to their thousands and thousands of voters, whereas other groups have millions of dollars to speak to many more voters. Well, you know what? There's a lot of groups in this state who don't have $100,000, who might only have a few $100s or a few $1,000s. And if you eat up their time and resources trying to figure out these rules, trying to attend classes to learn these rules, trying to hire attorneys, and then still getting the threat of being sued by their political opponents, that is what shuts people up. That is not transparency. That is not free speech. That is silencing speech. And I do want to emphasize that, right? The campaign laws invite people's political opponents to sue you over the laws. Why? It's vindictive, to take up your resources, to impose fines on you so you have to spend money on fines rather than advocating your beliefs. In fact, I don't think it's an accident. Diana and I opposed the personhood measure as I suggested. It's not an accident that our opponents were sued under these laws by another party. And I don't think anybody even raised the possibility of suing us. Why? Because on that issue, we agreed with the left. And yet our opponents, who were advocating this measure, which I think is horrible, by the way, they get sued under the campaign laws. That's not fair to me and Diana. I want a fair and unrestricted debate. I deserve that. I don't want my political opponents being dragged into court and spending their resources talking to a judge when they could be talking to the voters of Colorado. That's not fair. That's not freedom of speech. That's not transparency. So I do have a couple of specific ideas regarding your rules. One is a brief aside that just occurred to me regarding the major purpose, whether it's percent or a dollar amount. Let me back up for 1 second. I do appreciate that the Secretary of State is bound by the Constitution and the Colorado statutes. and then the court decisions regarding this. So there's actually 4 levels of rules that the citizen activist has to try to learn. And you're one of those. So I realize you're working within the constraints of the other 3. And so I do appreciate the fact that your rules are a good faith and progressive effort to make sense of the rules and to make them as less onerous as possible within that framework. And I appreciate that. So my minor point on this major purpose, maybe something that would be workable within that framework, would simply be to say a percentage or a dollar amount. In other words, if you're a huge group that says, with a $10 million, right, and you spend $1 million on this one issue, well, maybe the trigger would be the dollar amount, not the percentage, right? So that might be one way that you can work within the system to make that work out a little bit less onerous. But I'm particularly interested in the $200 to $5,000 trigger. And I just wanted to, I know that the Secretary of State's office is well aware of this, but I just wanted to emphasize the point that this is not optional for you to raise the threshold from $200. It is, my reading, a mandate from the 10th Circuit Court to review that case, which I looked up last night. In a footnote, they described how much money the group in question actually spent. And let me find my numbers. So it was this amount, $782.02, plus an additional amount of $1,178.82, which, quote, went for attorney fees, and $247.18 remained in the committee bank account. So notice that even this group, right, spent far more money getting sued over the measure than they actually spent promoting their ideas, which is quite wrong. And so the total for that is, by my calculation, $2,208.02. All right. So by the 10th Circuit ruling, and the 10th Circuit doesn't say an exact figure, right? But it does say that that amount is well below the constitutionally mandated amount under the First Amendment. All right. So at a minimum, we have to start the discussion at $2,208.02 to meet the First Amendment barrier. But really, your threshold has to be well above that, taking the court's language. And $5,000 is a reasonable effort to come to grips with that language, and so I appreciate that. And I believe that, there's various other rules which I have not looked into in greater depth, but in general, I think you've made a good faith effort to make the rules as intelligible, as objective, and as less burdensome as possible within the given framework. So thank you.
Thank you. As I think about it, our lawyers, it's more like a special forces team rather than a battalion.
Okay,
I would like to say.
We'll downgrade from a battalion to a team.
And you called me progressive. I want the record to reflect that as well. Thank you very much. I do appreciate it.